one and all who have joined this IP Manthan. The objective of the IP Manthan series is to invite the discussion deliberations on the current and the futuristic discussion topics on which we collectively can strengthen the entire IP ecosystem. And I thank the legal team working with me and the HOs and the other controllers, examiners involved in the exercise of framing the new patent amendment rules. The work has already been paid off. I can say that the new rules, after a gap of few months, it has come to the public for now. Invite the consultation earlier, and based on the consultation, each and every submission which we have received, that has been taken into the consideration, and after consideration this has been vetted at a government level, and it came into the public on 15th of March. And now these rules are notified, so it is in force. I have thought of sharing the few insights about the Patent Amendment Rules 2024. And as you all might have studied, but still wants to highlight that key provisions which are much more progressive and offering aids in the protection of IP in India. And these progressive provisions are setting a new trend in the IP ecosystem. And this new trend is going to offer much amplified benefits to the applicant who wants to protect their invention in India. There are a couple of provisions which are enabled in the manner which offers aids in compliance and reduce the efforts for the compliance, and yet maintain the same level of requirement under the provisions in the Act. To go more specific, I would like to highlight one or two provisions in this discussion, and I am sure all of you might have studied them, but still I would like to mention it here. Like under Rule 29A, the grace period provision. So an applicant avail the period specified under the section 31. The section 31 was already there, but how to utilize the flexibility of section 31 and how this flexibility can be enabled to practice, it was not clear, and many stakeholders were making a submission, but it was not appropriate to follow into the practice. So that's why Rule 29A got introduced, and in order to practice this, it was essentially required to have a Form 31. And Form 31 is designed in such a way that it is simple for any inventor to make appropriate submission and support this appropriate submission as well. And by doing this so, they can claim the grace period. So during this period, under the section 31, if they wants to avail the flexibility, then they can avail the flexibility which is already there in the current IP Act. And any prior disclosure or anticipation coming in by the public display will offer them the protection which is available. And within the 12 months, if they have made any public display, then they can make this submission to ensure that their invention is not harmed by this. Most importantly, the provision was there in the Act. Now this rule offers the nitty-gritty through which they can enable this provision to protect their invention. The second such important provision which is going to offer a much welcoming recognition, I can say that. And I, being a inventor in couple of patents, so realize that when I got my first patent, in a patent certificate, the applicant's name was capturing the academic institution name. I filed through the academic institution. And nowhere the work which was done by the inventor was getting reflected. And certainly I would like to make a submission. At that point in time, we were not aware that section 28 under Form 8, we can have the name of inventor as such into the patent certificate. And after the grant of a patent, it is difficult to do this kind of changes in the granted certificate. The Act does not provide this. So once the patent is granted, it is difficult to recognize the contribution in an official manner. So new provision under Rule 70A got introduced. And this new rule allows inventor to apply for the certificate of inventorship. And it has been designed in such a way that inventor himself or herself can apply it via online mode and do the necessary submission, even the payment of a fees also, and the address, phone number, email ID shall also get verified, so that certificate of inventorship is digitally reaching to the inventor's email ID. This has nothing or no correlation with the IP rights of the applicant. This is a purely one declaration submitted before the IP office in Form 5, Declaration of Inventorship. And based on the Declaration of Inventorship, if the decision is positive to grant the patent, the declaration of inventorship given by each inventor is entitled to get the certificate of inventorship. Rules are already notified. The IT team is already on job to make this provision enable ASAP. And we will make a formal announcement of this provision getting available, accessible to each inventor. And they will get the certificate of inventorship under this. More importantly, the patentees are filing the annuity payment. And for 4 years or more, if they are certain to maintain this patent and they are filing the fees via online mode, then the applicant will get a rebate of a 10% for the advance payment which they are making. And this 10% is going to get incentivized for online payment only. So encouraging the applicant to pay the annuity fees in advance and also encouraging them to pay via online mode, so that without any hassle in payment, the provision will encourage them to protect their invention for longer duration. The other important provision which is there on a request for examination filing. The request for examination which was there in India for 48 months to file the RQ. And nowhere in the world, when we have started reviewing this, comparing the provision with the other leading IP countries in the world, then we have found that majority of these countries have a 30 to 36 months provision, coincide with their PCT timelines to enter into the national phase. India has a 31 months for any PCT application to enter into the Indian national phase. And secondly, if somebody missed this timeline, then there is a extension which is available for request for examination. And the 6 months of extension can be availed. But this extension is to ensure that the principle of a natural justice for all those who have missed the timeline. But our focus is on submission of an application on time following appropriate process. We have in recent past worked on a timeline and have optimized the entire IP process in such a way that we want to make sure that inventors are enjoying their IP rights under Chapter 8. And this Chapter 8 should be the enabling provision for each applicant to protect their IP right and to commercially also utilize this IP right. And hence getting the granted patent on time or even under Rule 24C before time also for the expedited examination. And before joining for this IP Manthan, I have analyzed the grant term for the last 23-24 patent applications. The 1 lakh grant which we have done it in the current financial year, 61% applications disposed of by the office which were from the backlog, and this backlog for 2 consecutive years, the 2022-23, 2023-24, we have tried to address this so that IP rights are available and enjoyed by the applicant. But most importantly, in the current year, 39% applications which are disposed by the IP office, which has an average time of disposal less than 30 months from the RQ filing. So this 39% applications has a highest term of 30 months and shortest time frame is much lesser. So we are moving into such a regime where we have not just the timely grant, but efficient processing of the application. And this processing, we want to continue this year as well. Now, if I count that how many applications I have pending, which are of 2019 or later, because in that case, the RQ filing date is already gone. So if they have not filed the RQ, the applications won't get the opportunity to get their application examined. So timely grant we want to ensure, and that's why at par with the international standard, we want to bring the Indian IP ecosystem as well. And that's why we have introduced this request for examination, timelines reduced to 31 months from the priority date or a date of a filing. And if somebody missed this priority, they can avail the request for examination filed within 6 months, that is up to 37 months. But again, there is no delay charges for the applicant who decide to enter in India timely. And further, all those applicants who have not yet filed the request for examination, there is a provision which has been made it clear from the date of publication of this. So for all those who have still the validity of a 48 month to apply, and the provision shall be available for all those applicants who are yet to take a decision for submission of their request for examination. One more important element in the recent amendment which we have introduced is related to Form 3. Under Section 8, statement and undertaking is given by the applicant that they will keep the office updated about the international filing, and while filing the application, Form 3 is getting submitted, and subsequently whenever any kind of a development is there or there was a need for the applicant to keep the office updated every 6 months, the information is useful or not, the legal provision was framed in a manner that there was a requirement under the law to keep the office updated. So every 6 months filing the same information or with minimal improvement on the information without any change into the international filing. Whenever such change is there, freedom is given to the applicant to keep the office updated. If they have not kept the office updated, if the things come to the notice of a controller, then controller will also access the publicly available information, will review them and will pass an order for applicant to furnish the fresh statement within 2 months. Now we all are operating into the digital connect, and getting the information from applicant has made it more easy to receive the information from anywhere in the world. So furnishing the fresh statement should not take a more time. But still, we have given a 2 months of a timeline from the date on which the applicant has received the order to furnish a fresh statement from the controller of patent. In case, even during these 2 months, applicant could not able to submit, then this delay can be condoned up to 3 months on a request using Form 4. But still here, we want each and every applicant to make sure that they are filing within the available time frame. This is the way we can collectively build the strong IP ecosystem for our country. When we are approaching towards the 2047, wherein we have a vision to have the more efficient IP ecosystem, then we all need to collectively work towards adhering to the timeline and ensuring the compliance and process is done within the timeline. If applicant, agent follow the timeline, follow the process, they will not be required to pay any condonation fee. But earlier there was a much more ambiguity into the system. So we have tried to make it clear, and with the appropriate form and fees specified in the schedule of fees, so that there is a defined clarity and all the agent and applicant can avail this benefit if they could not able to submit the essential information documents on time. If they submit on time, there is no way any kind of a condonation fee will be required to be paid. But equally, office is sensitive enough that we are a IP grant authority and we are not in any mode to discourage the applicant from getting their patent right conferred under the Act. So, under the principle of natural justice, we want to give the opportunity to the applicant to comply with the requirement under the Act and the rule. If they have delayed, their delayed can be condoned under Rule 137, 138. So this is something which is going to be beneficial not just to the applicant, also the attorney will make sure that the timelines are adhered by the applicant. Certain clarity which was required on the pre-grant and post-grant related provisions. And there was no time limit for controller to dispose of the representation. There was a provision for controller to review the representation received from the opponent, but without any timeline. So, controller has been directed by this rule to dispose of the representation received within 1 month by passing a speaking order, whether the opposition matter should be reviewed or should not be reviewed. The decision will be taken, and if it is to be reviewed, then the full-fledged pre-grant opposition proceedings will take place. Now, what is the benefit for the applicant and opponent in this? The matter has already been examined by the controller and is already under section 14 reviewed to decide the matter. So applicant is aware about what is going on in the prosecution. Controller is also aware about what is going into the prosecution. Opponent tried to bring certain evidence on table, and merely on evidence of table, it is difficult for the controller to decide whether the opposition is having a substance into the argument or not. So, opponent will get an opportunity to make a technical representation before the controller. Controller, based on the representation and the technical merit which has been put forward to him or her, will pass an order, and there is a defined timeline within 1 month. He will pass a speaking order that on these grounds the opposition proceedings will take place, and there will be a statement and counter statement submissions. So the entire pre-grant opposition proceedings, which was taking a longer time in argument and counter argument, this process is streamlined in the manner that both the opponent and the applicant gets the fair opportunity to make their submission, and purely on the merit which are decided to examine the case. Any new merit which is to be introduced, that will also be introduced during the proceeding, but the discussion or argument, counter argument will be closed so that matter can be decided. And again, here the spirit of introducing this provision is to ensure that the IP rights, if so granted, then the applicants can enjoy the IP right under Chapter 8 of the Indian Patent Act. even if the matter is going into the negative, say as a rights are not, the pre-grant opposition is result into the revocation of the patent. In that case also decision is taken, so that both the parties have the appropriate remedial action which is available into the Patent Act to execute. Same way in post-grant opposition matter also, the opposition board report was required to submit in 3 months. We have reduced it to the 2 months, so that there is a level of sensitivity and time-bound action at the IP office end. And within 2 months, they can submit this. One argument was there on a Rule 110. And when we have notified before the Patent Agent Exam 2024, we have received numerous queries. But now, from next Patent Agent Exam, all the aspiring candidates will have a Patent Act, Patent Rule, Design Act, Design Rule, and the associated provisions wherein India is signatory to the WIPO, and related questions will be the curriculum for the Patent Agent Exam 2025. And we have maintained the tradition of announcing the date or tentative date or month in advance. Detailed date sheet will come with sufficient time, but this year we have announced the date or month, November 25 is the month wherein we are possibly going to have the examination conducted for the patent agent, to become a patent agent for the IP office. And this time frame is given to make sure that the syllabus is going to be very lengthy and all the aspiring candidates can start preparing right after the 15th of March 2024. So many messages I have received on the social media, LinkedIn also. But now I would like to make a submission in this IP Manthan that November 25 examination will have both Patent Act rules, Design Act rules, and the associated details related to the patent ecosystem in country. And equally, all the patent agents can also practice the design, application filing and prosecution. So it is essential for all the patent agent to learn the Design Act. And I have received a question, so but I will respond to the queries once we open up the question answer. But yes, the syllabus is well defined into the new patent amendment rule. For next patent agent examination, both the Patent Act and rules and Design Act and rule are going to be the primary syllabus, and the associated information are related to India's commitment in the international forum, and that is the going to be the examination syllabus. On working statement requirement under Rule 131, it was required to be filed annually and within 3 months from each financial year which is going to end. And since we all are into the IP ecosystem, we know how frequent the development is happening in utilizing this IP and its working, and the way, the kind of a contribution which IP is generating. And in the Iyengar committee report, it was also mentioned about utilizing the IP for the commercial benefit for the society. Taking reference to this Form 27 we have optimized in such a way that there is a age in compliance to this requirement. The way Form 27 is designed, it is going to be a win-win situation for all those who have commercialized or going to commercialize or who are exploring the commercial utilization of IP. So there is one such question wherein they can explain or disclose that their IP which they have got granted is available for exploring on a commercial front. And all those statements made in official submission by the patentee, those applications will separately be listed on IP Office website. And through this, furnishing this information, the SME, MSME or commercial entity or those investor also who wants to explore the commercial utilization of IP, it will create a bridge between the patentee and the entities or individuals or legal firms who wants to commercially use the IP. And this disclosure will benefit to each and every applicant. And I'm not talking any kind of a sectorial exclusivity here. This provision will be available, accessible to each and every patentee. And the compliance to the working statement requirement starts from the financial year. So if your patent says granted in August 23, so your compliance requirement will start from March 24, and your Form 27 submission will be required to be made. And it will, the submission will get triggered March 25. And in previous provision, there was a 3 months of a time frame which was given. Now, under the new working statement requirement, from 3 months, it has been extended to 6 months. So, the information which is required to be furnished within 3 months from the April 25, May 25, June 25, and June 25, it was the closing time for the submission. Now it has been extended 3 additional months, and it has a 6 months from the expiry of the due date. And instead of filing this annually, this has been further simplified to comply with the requirement. And this compliance, instead of a 1 month, it can be furnished every 3 years and 3 financial years. So that there is a significant development which is happening while we are aiming to commercially utilize the IP and ensuring that there is a simplified compliance requirement. The form is designed in such a way that every applicant can make appropriate submission before the office. And if so, any additional information required based on their submission, then Controller General can ask for furnishing the additional requirement if so required by the office. So that it has been simplified in the manner that each and every patentee can comply to this requirement. And IP rights are also available for commercial utilization. If somebody misses this, then 3 months delay can be condoned on request. So instead of a 3 months of a compliance which was there in the previous rule, ultimately it has a 3x expansion in compliance to this requirement. And instead of annually, it has been simplified to furnish in 3 years interval. This is the aim of office, to make sure that IP rights are utilized effectively and there is a less burden on applicant on these kind of a compliance. So ease of IP utilization, like ease of doing business, once IP is granted, this is the ease of doing business utilizing the IP rights. There are certain other provisions also made on condonation of a delay or extension of a time in furnishing the various requirements under the Rule 137 and 138. These are optimized. There are certain revision into the cost structure also. But mainly, we are forward looking to ensure that the IP rights are not just a piece of a certificate. It is more on using the IP right for the benefit of the applicant and the patentee. One more on, I think, request for examination is also response to the request for examination is also having one amendment, right? So that there also there is amendment into this. I have tried to broadly cover the main important highlights of the patent amendment, patent rules amendment 2024. If you have any questions, queries, we have some time available to invite the questions. I will request Himadri, you can take the question in rotation. Take the questions which are posted on the chat box, and I will invite one by one to the
Sure, thank you, sir. I have enabled everyone to unmute themselves, and I request CG sir to kindly begin with the people who have raised their hands. Also, everybody kindly raise your hands, please be in turn, and also please unmute and mute yourself after you have asked your question to maintain a decorum of the session. Thank you.
Himadri, 1 minute. We will call the person and I will do this unmute. Okay. Otherwise, we will have an unstructured discussion. So let's have the one question from the chat box. You just let me know the question from the chat box. I will call the participant who have raised the hand. Okay. And we will one-on-one we will take it.
Sure, sir. First, I'll begin with the questions that are available on the chat box. As I can see, there are questions on, sir, can you please provide special provisions of fee reduction, filing and renewal fee, or schemes for students below 25 years to file patent and design application? Design application has only applicant and students have more idea about design.
Currently, it is a session for the patent amendments rule, and in patent amendments in 2017, the 80% fee reduction is already given to the academic institution and even the individual inventor also, along with the startups and SME. So this is already having the provision which you are submitting here. This 80% reduction is there. In design, I will study this and we will do the needful if so it is possible. Thank you. So now I will invite Prashant. Prashant, I am trying to unmute. You can. Prashant. Prashant, can you unmute? Or turn on your video so that I can see. Yeah. Himadri, you don't mute, unmute. I will manage this operation from my end. Okay. So manuals, already we have announced the submission, which is still open, and we have started working on this. If you have any suggestions on manual, you can make the submission to the CG office email ID, and we will appropriately review this. Ankush Mehta, I request Ankush Mehta to unmute.
Good evening, sir. I'm Ankush Mehta from Mehta Associates. Firstly, congratulations on this new patent rules. They definitely appear to be way forward and have taken out a burden on very large scale regarding procedural matters, which tends to be the hindering point. Now, my concern is regarding Form 4. Now, Form 4 has two new provisions. I'll go to Schedule 1, which one is regarding specifically mentioning is for Rule 12 and Rule 131, and one is regarding 138. Now, 138 previously had certain limitations. Certain rules were taken out of those provisions, which included new filing as well. And for, regarding Rule 12, Form 4 specifically states that you can go for extension by a period of 3 months. Right? Now, if I have a provision of 138 as well, which says notwithstanding anything contained in these rules, and there's no limitation specifically given, can I file a separate form for under 138 whereby I can take another extension of 6 months with that 3 months? And will the provisions like new filing rules also undercome 138? If so, then how? And my basic reason for asking this question is law permits to grant the maximum amount of extension if there are multiple kind of time durations available to right seeker. So if I have 3 months extension and I have 6 months extension, then by simple logic, I should be able to claim 6 month extension. But since these are two separate provisions,
yeah,
Ankush.
Ankur, I have
Yes, sir.
understood. This is a two specific questions on the and it requires to be examined in light of the particular application which has this kind of a case. So it would be good. I invite you to make a written submission to the office. Let me just examine this and appropriate clarity if it is required to be made. We will make it to you, or if required, then we can also make a public statement on this, so
Sure,
that
sure.
there is an adequate amount of clarity to all the stakeholders. So good that you have a very important question, but it is more on going into the specificity of a
Indeed.
particular application, and I encourage you to make a specific submission citing few applications so that it can be examined, the current provision can be examined in light of a few such case studies, and
Sir,
then
I can definitely.
we
Sir,
can make a public comment on this. Public notice can also be issued, or we will also invite a discussion specific to this. Okay.
Sure, sir. Thank you.
Thank you. Thank you. Yeah, Himadri, one more question from chat box.
Sure, sir. Sir, we have a question from Dr. Harikrit Kaur. Sir, please clarify this. Suppose the patent is granted in the year 2023, 2024. So the working statements will be filed on 31st March 2027 and deadline will be 30 September 2027.
Yes. After the next 3 financials, keeping the 3 financial year. So if this is getting granted in 23-24, the trigger will start from 25, 24, 25, 25, 26, 27, 28. So their submission requirement will be April 28 and 6 months from that. So yes, they have rightly understood this provision. Okay.
Thank you, sir.
Thank you. Yeah, now I will invite from online Raghavendra Singh.
Yes, sir. Good evening, sir.
Good evening.
Sir, my question is, as we have filed many FER responses and there is backlog of cases. So in many cases, we didn't meet the formal requirements like POE was not submitted or some like document like translation of the priority document was not submitted. So earlier we used to file petition under Rule 137 to obviate the irregularity. Now that is like barred by the amended Rule 137.2, which was earlier in the 138.2. And the fee for the condonation or whatever is like that is like 50,000 per month. First thing. Second thing is, sir, if the 6 month period is already lapsed, let's suppose we have submitted the responses sometime in 2015 or 16.
Under the
So the maximum. Yeah.
Raghavendra ji, I have understood there are quite a huge number of applications where the power of attorney is not filed. Earlier,
Yeah.
without working on any application,
Yeah.
without the power of attorney, is
Yeah.
something which is not a good IP practice.
Sir, I do agree
Here,
with you. Sir.
Raghavendra ji, एक minute, let me just
Yeah.
respond. Now I have understood your question, and you have also understood the kind of a condonation fee which is there. So
Yes,
I
sir.
have
Yes, sir.
understood your questions. Let me clarify here. Okay.
Yes, sir.
So here, for any patent application which
Yes,
is
sir.
being filed through any patent agent,
Yes, sir.
it is essentially required to file with the consent of applicant. Power
Yes, sir.
of attorney is something where the applicant is giving you the consent to make appropriate submission on their behalf. And when I have joined this office, and during this almost 23 months of my tenure in this office, I have seen several cases where power of attorney is not getting filed for years, 8 years, 9 years, 12 years, 15 years. And our controllers are asking for the appropriate submission, which is the bare minimum requirement. We don't know who is the appropriate person to deal with this application. They appear, they defend, but they are not simply bothered to submit the basic requirement under which they are authorized by the applicant to appear on their behalf. Now, this is a clear case of a breach into the legal compliance under the Patent Act. We encourage all the practicing attorneys, agent. You are the ambassador of the IP ecosystem in India. And you should be following the rules which has been defined in the Patent Act and patent rules. Don't encourage any kind of a submission for which you have been forced by the applicant. And even in case you are filing and applicant is not available, there is a provision of 3 months to make this kind of a submission. Now, in the digital era, where even digitally notarization is also done in India, and this has been found valid by the Delhi High Court. तो अब ये कोई एक्सक्यूज नहीं बन सकता कि ये नोटराइज नहीं था, ये करने में टाइम गया, ये फॉरेन में बैठा है. Digital notarization easily available, accessible to everyone. So this can also, there is no excuse to do this. But we want to make sure that the compliance is done. Agent and applicant must have the power of attorney to represent the applicant.
Yes, sir. Sir, I do agree with you.
Grant, 1 minute, Raghavendra ji. Before
Okay, sir.
grant,
Okay, sir.
it is becoming a bottleneck. 10 साल 12 साल बाद ये बेसिक फॉर्मेलिटी क्वेरीज रेज करके उसके कंप्लायंस के लिए हमें कहना पड़ रहा है. इस बार जो काफी सारे पेटेंट ग्रांट हुए उसमें से कुछ नंबर ऑफ पेटेंट ऐसे भी थे जो ये बेसिक से फॉर्मेलिटी कंप्लायंस में अटके हुए थे. ये
Yes, sir.
सारी चीजों में वी हैव टेकन अ प्रोएक्टिव स्टेप to allow this kind of a submission done on a war footing, and we could able to dispose them. Now, there are certain applications where still the power of attorney is not done, or the timeline for submission of the power of attorney is expired. Let me receive the appropriate submission from the attorneys, and we will make a public announcement to deal with those cases. We don't want to discourage the examination, prosecution of this application. So maybe a one-time submission, maybe think of, but we'll see how many such cases are there.
Yes, sir. That's all I wanted to know, because let's suppose.
But this is again, ensure that within 3 months the power of attorney is submitted.
Yes, sir.
But सबने सीख लिया है डिजिटली कैसे कनेक्ट होना है.
Yes, sir. Yes, sir.
इवन फिजिकल डाक से भी हम कहीं पर भी विश्व में बैठे हुए एप्लीकेंट से डॉक्यूमेंट एग्जीक्यूट कराने के लिए साइन करके रजिस्टर कोर्ट से मंगवा सकते हैं, कुरियर भी नहीं.
Yes, sir. Yes, sir.
रजिस्टर कोर्ट से भेजना और रजिस्टर कोर्ट से वापस लाना और उसको यहाँ ऑफिस तक पहुंचाना. तो एक्सट्रीम कंडीशन को भी ध्यान में रखते हुए सफिशिएंट टाइम इज गिवन.
सर बहुत बार ऐसा
beyond this we don't want to discourage the applicant in complying to this requirement. They can very well ensure that they have the appropriate representation by the attorney, and this representation, if they are delayed, then they can file through filing of appropriate fees. But those applicant, those patent agent, patent attorney are complying with within the timeline, they don't require to pay fees under 138 or 137. कोई एक्स्ट्रा पैसा देना नहीं है. मैं यहाँ पब्लिक फोरम में आप सभी को अवगत कराना चाहता हूँ, फिर से हिंदी में बता रहा हूँ. अगर टाइम से जो कंप्लायंस पेटेंट एक्ट या रूल में करने हैं, अगर वो करते हैं तो कोई भी कॉन्डोनेशन फीस पे करने की आवश्यकता नहीं है. और ये बात सारे ही पेटेंट एजेंट और पेटेंट अटर्नी जब ये कंप्लायंस फॉल होता है तब अपने एप्लीकेंट को इस कंप्लायंस के बारे में अवगत करें और ये भी बताएं कि अगर ये नहीं होता है तो इतने टाइम फ्रेम का कॉन्डोनेशन हो सकता है, for which they will be required to pay XYZ amount of fees, so that the person who has to take a decision at an applicant end will have a complete clarity in compliance to the requirement of a patent act and rule, and it is their call to furnish the requirement on priority or at their appropriate time. Okay, thank you. Himadri, we can take a question. Yeah, Raghavendra, we will come again. Let me give, I have so many raised hand, will give the opportunity to possibly maximum number of people.
So there is no column of sales or revenue data in the new form 27. Please elaborate how can patentee disclose the patent is being commercially utilized?
Sorry, can you repeat?
Yes, sir. So there is no column of sales or revenue data in the new form 27. Please elaborate how can patentee disclose that patent is being commercially utilized?
So wherever such information will be required by the IP office, a separate communication will be sent to the applicant. and applicant will be required to furnish this requirement within the period specified under the rule. But we want those applications wherein the questions, queries which is required by the office, on those applications, they will patent, they will be required to furnish it. NOMS, somebody is there. Either you change name or mute it, because this is creating the disturbance in the IP office. Himadri, you can unmute.
Yes, sir.
Yeah. Next question.
So the non-retrospective effect has been mentioned specifically for request of examination only. Does that mean that the rest of the timelines have retrospective effect? If yes, what about Form 3 in the cases where it has been more than 3 months that FER has been issued? Of course, this is for FERs issued before notification of the new rules.
Yeah, in that case, they will have to submit within the rules prescribed into the newly amended patent rules. But certainly the 48 months requirement, the extension to that is given to only those applicants who are yet to make a submission. Say as somebody is having a 44th month of the priority date, so they can still make the submission. So now onwards, this requirement will be enabled. Okay, and Form 3 can be submitted even if they have any update, they can make a submission. Okay, thank you. Afzal Hassan.
Yeah, good evening, sir. This is Afzal Hassan from Hassan and Singh, Hyderabad. And first of all, sir, thank you very much for this open platform where we can discuss, where we can sort out our queries. So I have just 1 or 2 queries and some of my observation, which I would like to share. My first query is, like just now this Himadri asked, someone has already raised this query, that this regarding Form 18, this timeline has been reduced to 31 months, but provision is made for the old applications to follow 48 months. But sir, in Rule 55.4, timeline earlier used to be 3 months from the date of notice by the controller. Now, sir, in those cases where already notice has been issued under Rule 55.4 and specifying that the 3 months time is given to you to submit
तो
your
3 महीने का रहेगा.
3 months will apply.
अभी जिसका ऑलरेडी नोटिस चला गया है उनको 3 महीने का समय रहेगा. नाउ ऑनवर्ड्स जो नोटिस जाना है उसके लिए ये टाइमलाइंस एप्लीकेबल हो जाएगा. ठीक है. थैंक यू अफजल.
सर आई हैड वन मोर क्वेरी सर.
अफजल जी एक क्वेश्चन रखिए तो अच्छा है क्योंकि आई हैव अ लॉन्ग लिस्ट.
Sir, actually already Mr. Mehta has raised this thing. Sir, regarding Rule 138, sir, I think there is certain, you can say, review is required because sir, language of Rule 138.
आप रिटर्न सबमिशन दीजिए जहां पर देखिए ये स्पेसिफिक चीजें हैं. जो कॉन्डोनेशन वाला है ना, कॉन्डोनेशन वाले प्रोविजन 137, 138 में आप सीजी ऑफिस में अपना सबमिशन दीजिए. दिस कैन बी एग्जामिन. एक मिनट इनको बताओ लग रहा है मीटिंग चल रहा है. सो ये सारे प्रोविजन में हमें उस केस को स्पेसिफिक एग्जामिन करके ही बता सकते हैं. देयर कैन नॉट बी जनरल स्टेटमेंट मेड in case of a 137 and 138.
सर मेरा एक रिक्वेस्ट है सर on this forum. Sir, I request you to please organize one meeting of the attorneys with the controllers. सर क्या हो क्या रहा है?
पक्का करेंगे।
यूनिफॉर्मिटी नहीं रहती है
अफजल
सर।
हसन जी,
जी सर।
अभी भी देखिए सारे ही एप्लीकेंट एजेंट के साथ बात करने में हमें कोई परहेज नहीं है। हम तो खुद सामने से बात करना चाहते हैं, ठीक है ना। तो
सर
ऐसे
मैं
जितने
एक
भी, और
एग्जांपल दूंगा सर।
मैं सामने से कह रहा हूँ 137 138 में ये सारे क्वेश्चंस क्वेरीज हैं, उसमें स्पेसिफिक क्वेश्चन स्पेसिफिक आंसर हो सकता है। और
नहीं सर।
उसको जनरलाइज करने के लिए आप कुछ ऐसे केस बेस्ड सबमिशन दीजिए, ताकि मैं यहाँ अपने टीम के द्वारा इसको एग्जामिन करा के क्या अप्रोप्रिएट रिजोल्यूशन अभी वन टाइम भी अगर देना है तो कैसे हो सकता है अंडर द लॉ, ये कैसे पॉसिबल किया जा सकता है।
श्योर
मैं
सर।
उस दिशा में सोचने के लिए कह रहा हूं। तो आप मुझे रिटर्न सबमिशन दीजिए विथ
नहीं सर, इसके
स्पेसिफिक
अलावा सर
एग्जांपल,
एक रिक्वेस्ट है
आई
सर
विल
मेरी।
सीरियसली मेक इट कंसीडर्ड, ठीक है।
श्योर
तो
सर,
आप
मेरी एक
चिंता मत
रिक्वेस्ट है।
करिए।
सर
आई विल कॉल
अदर देन
नेक्स्ट।
138
अफजल जी, आपके
सर।
बहुत सारे क्वेश्चन मैंने सुन लिए, बहुत लंबा लिस्ट है। आई नीड
सर
टू
वो
गिव
एक
द
रिक्वेस्ट है सर,
अपॉर्चुनिटी
वो
टू एवरीवन। सॉरी
हम
सॉरी।
सभी की ओर से एक
हिमाद्री,
रिक्वेस्ट है।
नेक्स्ट प्लीज फ्रॉम चैट बॉक्स। अफजल जी आप रिटर्न सबमिशन दीजिए, आई विल मेक अ नोट ऑफ दिस, ठीक है
श्योर सर, आई विल
जी।
डू।
थैंक यू।
Thank you, sir. For applications that have been granted, Form 27 will have to be submitted as per the new rules every 3 years, or this is applicable only for the cases after 15th when new rules came into the force.
नाउ ऑनवर्ड्स जो फॉर्म 27 सबमिट करने हैं उनके लिए ये 3 साल का टाइम फ्रेम लागू हुआ है। अभी सपोज लास्ट ईयर or last but 1 year before you have got the granted patent and it was falling in say as a 23 April and you have made a form 3 submission, this year you can avail skipping this, but it will then fall from the 3rd year of from the date of grant. तो ये आपको अनेबल होगा तीसरे साल। अगर आप 5th ईयर में है तो आपको 6th ईयर में होगा, 7th ईयर में है तो 9th ईयर में होगा। सो रेट्रोस्पेक्टिवली ऐसा लागू नहीं हो सकता। जितने ग्रांट हो गए उनके लिए ये अनेबल्ड है 3 साल वाला। इसको प्रॉपरली कैलकुलेट करना पड़ेगा। इफ रिक्वायर्ड वी कैन इश्यू पब्लिक नोटिस टू क्लैरिफाई दिस ऑल्सो, ठीक है, ताकि डेट कैलकुलेशन में एक आध एग्जाम्पल लेके हम उसको और अच्छे से क्लैरिफाई कर सके, ठीक है। सो टेक अ नोट, वी विल क्लैरिफाई दिस बाय इश्यूइंग अ पब्लिक नोटिस ऑन दिस, ठीक है। थैंक यू वेरी मच। अंजन सेन।
Yeah, good afternoon, sir. So this is Dr. Jayati Vishwas representing. I have query related to Form 1, sir. Because in the Form 1, there is a checkbox box where you can, you have to take the permission if you are using NBA permission, if you are using biological material. So my question is, according to the new amendment in Section 6 of NBA Act, where only registration is necessary, okay, where if you are not commercializing your patent, so that
अंजन जी, हाँ अंजन जी, ये अभी जो आईपी मंथन है, it is well within the purview of the patent amendment rules 2024. इसके लिए हम अलग से मीटिंग करेंगे। इफ यू हैव एनी रिटर्न सबमिशन, मेक द रिटर्न सबमिशन सो दैट वी विल हैव द डिस्कशन ऑन दिस, ठीक है। तो अलग से हम इस पर बात करेंगे। अभी ये टॉपिक जो है उसी के ऊपर हम क्वेश्चन करें तो अच्छा रहेगा, ठीक है। थैंक यू वेरी मच जी। हिमाद्री फ्रॉम द चैट बॉक्स, क्वेश्चन फ्रॉम द चैट बॉक्स।
So one inventor approached me to file Form 8A. While checking the online form, there is no option for POA. Does it mean that inventor has to file Form 8A on his own?
हाँ, अभी Form 8A सबमिशन का पूरा आईटी कोडिफिकेशन अभी हम कर रहे हैं। हम उसकी पब्लिक अनाउंसमेंट भी करें। वी विल मेक द अनाउंसमेंट once this Form 8A online submission is available. we will make this public announcement done. If you want to submit in a physical mode में भी हो सकता है अभी, है ना? Individual can do this. और इसमें इंडिविजुअल को एनकरेज कर रहे हैं. OTP वेरिफिकेशन हमने इसीलिए रखा है कि इंडिविजुअल का ईमेल आईडी वेरीफाई करे वो खुद, उसका मोबाइल नंबर वेरीफाई करे वो खुद, ताकि जैसे ही ये सर्टिफिकेट ऑफ इन्वेंटरशिप तैयार होके ईमेल होता है तो एप्लीकेंट ऑफ दिस फॉर्म 8A will come to know and will receive the alert from the office. ठीक है? And soon we will make the online submission also made available. The team is working on war footing. Thank you very much. Nanki ji. Nanki ji.
Good evening, sir.
जी, good evening.
So my first question is with respect to, वैसे आपने बोल ही दिया है AWRs के लिए कि फॉर्म 27 के लिए क्लैरिफिकेशन आप इशू करेंगे, पर फॉर ओल्डर केसेस सर डू वी फॉलो द 3-year पैटर्न नाउ फॉर द नेक्स्ट फॉर्म 27?
Yes.
ओके. एंड
Thank
सर
you.
जो
आप एक क्वेश्चन पूछिए. मल्टीपल क्वेश्चन में मेरे पास बहुत सारे लोग हैं. ठीक है?
सर ये एक्चुअली
If I have
कवर हो
already
गया.
answered, try to skip this question so that we
Okay.
can have a unique questions in this IP Manthan. Okay?
सर रिक्वेस्ट फॉर एग्जामिनेशन के लिए इसीलिए क्वेश्चन है जिसपे क्लैरिफिकेशन है कि 48 months अप्लाई करेगा फॉर ओल्डर केसेस, तो उनको भी सर एक्सटेंशन का ऑप्शन है अंडर 138?
नहीं, उनको
Okay.
एक्सटेंशन का ऑप्शन अवेलेबल नहीं है. ठीक है?
ओके, थैंक यू सर.
चेक बॉक्स का क्वेश्चन.
Sorry, sir, I was on mute. What is the timeline to apply for the divisional application, which takes priority from provisional application filed in India under Rule 13(2)(a)?
Any time before grant of a patent. एनी टाइम बिफोर ग्रांट. टाइमलाइन में कोई चेंज नहीं है. ठीक है? ये अगेन दी अनेबलिंग प्रोविजन कि जो भी सबमिशन आईपी ऑफिस के पास आता है वो सबमिशन में जो चीजें डिस्क्लोज की है विच इज रिलेटेड टू इन्वेंशन, मे बी एट द टाइम ऑफ अ फाइलिंग पीपल मे नॉट हैव क्लेम्ड इट. That doesn't mean the adequate amount of a research and intellect has not gone into the matter which are disclosed. So divisional file कर सकते हैं. Divisional की priority same first application की priority ही रहेगी, so that their IP rights are maintained before the first application is getting disposed by the IP office. ठीक है? And again, this requires the adequate amount of a clarity on a case-to-case basis. So, if any further questions, queries are there, feel free to write to the office so that we can offer the adequate quality. Gnan Lex, please unmute. Gnan Lex is not available. Pratibha Siva Subramaniam, please unmute. Pratibha Siva Subramaniam.
Hello, sir. Thank you for your detailed explanation of the rules. I have one query regarding the fees for pre-grant. As you may know that most of many of the drugs in the national treatment programs have been opposed by the patient groups, and they are now free for generics to be produced, including the latest recent TB drug bedaquiline that was opposed by patient groups only, not even generics. and now it's available for people to be used in general. So this was possible because the pre-grant opposition fees was not there. And now the fees has been introduced. It will be a fatal blow for the patient groups to oppose these patents. And you may also appreciate that there is a public interest in the grant and non-grant of the patent. So that is the one of the concerns that we have on this issue.
Pratibha
Secondly, sir, this time that of 1 month that you have given for the merit to understand the merit, that is a bit of concern because most of the time now even the notices on the pre-grant opposition are not going to the applicant. So suddenly this 1 month will there be the decision in 1 month? Will the notice will go to the applicant after this 1 month?
Pratibha, let me just clarify. Within 1 month, matter will not be disposed. The 1 month is to hear the opponent and whether there is a merit in the opposition or not. And within the 1 month, the opponent's grounds of opposition will be reviewed and discussed with the opponent. And the merit of the opposition and its ground will be decided on which we will be passing a reasoned order, speaking order, to start the proceeding of the opposition matter. And I recall that you have also made a submission when the rules were announced. So
yes, sir.
These submissions have already been taken into the consideration. And regarding your previous question, we will see how this can be dealt with, because majority of the pre-grant opposition which has been filed are not falling into this category which you are representing in your submission. So we have to think separately on this, how this can be addressed. But we have studied the whole lot of pre-grant opposition which is being filed on a different class of application, different subject speciality of application. So we have to design a policy rules looking into the macro vision under which all the stakeholders who apply for the IP rights are getting covered. And in your case, we need to have a specific separate review in this matter. Make a written submission on this. We will see how we can discuss this particular matter. Thank you. Thank you very much. Himadri, next from the chat box.
So this is a very requested question which says, if Form 3 has not been filed since filing application, FER has also released and application is under hearing now, no foreign filing taken place in this case. So the question is, FER has also released the application and application is under hearing now, is the question.
नहीं है तो नील सबमिशन की बात नहीं है. अगर आपका उस वक्त भी फाइलिंग नहीं हुआ है, इंटरनेशनल फॉरेन फाइलिंग नहीं हुआ है, अभी भी नहीं है, तो आपको ये लागू नहीं हो रहा है.
Sir, my question is in this connection, sir, most of the time, even though applicants are not at all interested in a foreign filing, still we are receiving that form, file the Form 3. Also, today when I tried to upload Form 3 on a portal, it was mandatory to mention whether same or substantially same invention will be filed abroad, but applicant is not at all interested in abroad. So I think one tick mark shall be there.
Dr. Preeti, we will give the clarity in a public notice. I appreciate if you could make a written submission in this. Okay, so that we will examine the entire merit of the case and appropriate public notice will be issued to clarify this matter. ठीक है? Dr. Preeti ji? Okay.
Yes, sir. Because
Okay. Yeah.
thank you, sir.
Thank you.
Thanks.
Thank you very much. Yeah. Shikha Mittal. Shikha Mittal ji.
Yes, sir. Sir, this is Shikha.
Ji.
Sir, we have a question that earlier in Rule 138, the extension for PCT national phase filing was not allowed. But now this 138 petition, it says that anything contained in these rules, time specified for doing any act or taking any proceedings. So that's mean, can we take an extension for filing the application in India? Say if we have a PCT application which has a deadline for 31 months. So can we file after 31 months also along with the petition?
We need to check with the provisions under the PCT Act, but we have only 31 months under the PCT Act. PCT, we have allowed the national phase entry. So there is no dilution in or extension in the national phase entry through PCT route. There will be a timeline of 31 months, no extension, no delay, no condonation.
Okay, and the same with Paris Convention?
There is no dilution on the India's commitment to the or timelines which is agreed in the international agreements. So no dilution. This is for the remaining procedural changes which is there. Okay. Thank you. Thank you very much.
Okay, thank you, sir.
So from the chat box, we have a question about can you please confirm the time period deadline for pre-grant and post-grant oppositions?
Currently, there is no timelines in the or deadlines which is prescribed in section 25(1) or 25(2) in the Act, and the timeline cannot be brought into the rules. So it will be decided on the merit of the case. Thank you. Jogeshwar Mishra. Yeah, Jogeshwar Mishra. Aviral Goyal.
Hello. I'm sorry, Sai. There was a lag. I'm so sorry. Can I say this is Jogeshwar Mishra?
Yeah, Jogeshwar.
Sir, first of all, thank you very much for taking the time for this. I had just one very small query, which had been addressed in parts earlier. So this is regarding Form 3, which is due after the issuance of a first examination report. So let's say the first examination report was issued 4 months or more in advance of the amended rules. Do we need to file Form 3 with along with an extension request on Form 4 because the 3-month period has passed?
This will be clarified in a public notice. We will examine such cases, make a written submission so that appropriately we can clarify this. Okay.
Understood, sir. Understood. Thank you so much.
Thank you. Yeah. Aviral Goyal.
Hi, sir. Sir, just wanted to confirm. So for the applications now filed before the amended rules and after the rules, what would be the fee applicable for especially for the applications filed prior to the amended rules? So for example, formalities, application, condonation fees, Form 4 fees. So what would be the applicable fees for that?
ये notify होने के बाद तो अभी जो fee structure है वो लागू हो गया.
Okay, sir.
So this new fee structure which is notified will be applicable, and timelines will also be applicable on specific cases where there is a significant amount of application, where the RQ case is there, request for examination, it has been clarified. On remaining compliance, we will see how this can be dealt with. Okay.
Okay. And sir, for
Thank
like
you.
for example, now the fees is not showing on the portal. So what would be that? So it will be have to pay it on a later stage, or what would happen?
नहीं, ये पुराना जो फी स्ट्रक्चर है उसमें जो चेंजेस हुए हैं,
Yes,
विथ
sir.
चेंजेस इट इज एप्लीकेबल. अभी आईटी टीम शायद उसे अपडेट करके नया फी स्ट्रक्चर वहां पर वेबसाइट में फॉर्म्स एंड फीस में तैयार कर रहे होंगे, बिकॉज दे आर ऑलरेडी वर्किंग. So they might have taken off from the website for some period of time till they update and make it live with the new rules and new fee structure. Okay.
तो उसी में जैसे जो भी हम
It will
आज
be
फीस पे कर रहे
visible
हैं,
on the website also. Okay.
सो तो वही जैसे जो हम फीस आज पे कर रहे हैं उसका जो लेट सपोज हमने कोई पिटिशन पे 8,000 पे किया, बट अब वो 50,000 हो चुका, तो बाकी का 42,000 का डेफिसिट बाद में पे करना होगा?
नहीं, वो नोटिफाई होने के बाद अगर है,
यस सर, नोटिफाई के बाद.
तो फिर शायद उसके लिए क्वेरी निकल सकता है. ठीक है, या उसके ऐसे जितने केसेस हैं हम बल्क में इसको एग्जामिन कर रहे हैं.
ओके सर.
उसमें किस तरह से हमें डील करना है, वी विल टेक अ व्यू internally also, we'll take a guidance, legal guidance also, and appropriately we will make it available, clarity available in a public notice. Okay.
Right.
Thank
So,
you.
sir,
Thank
in
you.
that case, extension wouldn't be harmed, right? If lesser fee has been paid because portal is not showing that fee.
आप लीगल लैंग्वेज में मुझे एक ही उत्तर का, एक ही प्रश्न का जवाब अलग अलग तरह से पूछेंगे तो मेरा उत्तर यही रहेगा कि हम एग्जामिन करेंगे और एडिक्वेट पब्लिक नोटिस इश्यू करेंगे. एंड वी आर येट टू एनालाइज कि ऐसे कितने केसेस हैं जिसमें जैसे पावर ऑफ अटर्नी फर्निश करना बाकी है, ऐसे कितने केस हैं, और कितने केस में ये कॉन्डोनेशन डिले के लिए हायर फीस चार्ज हो रही है, आज एप्लीकेबल हो रही है. तो क्या इसमें स्टैंड लेना चाहिए? वी नीड दी clarity from the finance also, internal finance. तो IF डिपार्टमेंट से भी हम क्लैरिटी लेके अप्रोप्रिएटली पब्लिक नोटिस इश्यू करेंगे. ठीक है, थैंक यू.
राइट सर, थैंक यू.
एन कमुता. एन कमुथा. हेलो. Kamutha ji, we are not able to hear you. Yeah, we can take the chat box question.
Sir, I have a frequently asked question again. The questioner says that can we apply for certificate of inventorship for the previously granted patent? What is the right time to apply for Form 8A? Can we add multiple inventors in a single Form 8A?
फॉर्म 8A के प्रोविजन में ही क्लेरिफाई कर दिया गया है कि जो ऑलरेडी अवेलेबल पेटेंट है के इन्वेंटर को भी ये प्रोविजन एप्लीकेबल है. दे कैन यूटिलाइज दिस प्रोविजन, दे कैन अप्लाई फॉर दिस फॉर्म 8A and get the certificate of inventorship. All the existing patents are available and their inventor are eligible to get the certificate of inventorship. Till the form 8A is not made available online, they can utilize the published application form, make it convert into the digital and make the application in the same format which is published. Okay, that published form can be utilized for the physical submission of a form 8A. And on counter, they are accepting the newly published form 8A with the prescribed fee as notified into the Patent Amendment Rule 2024. Okay. Thank you very much. So we have already passed the timeline for the IP Manthan. There are significant raised hand which is there, and also we have so many questions which we have received in the chat box. So I am collecting, Himadri, if you can collect the questions from the chat box, if you can save it, please do the needful to save this question. Okay. And secondly, I feel that the separate open house is required for the discussion on the patent amendment rule, and all the questions and queries may be required to address in open house. So I will see if we can plan an open house. We will announce this open house maybe in a day or so. We will try to notify the date of an open house dedicatedly for the questions, queries on a patent amendment rules 2024. So you all can join the open house, and we will one by one allow the questions, queries on the patent amendments. Okay. So thank you very much for joining this IP Manthan. This IP Manthan means a lot. It was essentially required to clarify the grounds under which the enabling provisions has been made available, accessible to each and every applicant. And core strategy behind having such a positive and forward-looking provision enabled in the interest of the patent applicant is to make India more IP friendly and more IP ecosystem strengthening provisions are introduced. I am sure this will be taken up in a right spirit and right manner to enable the opportunity available, accessible under the Patent Act for each and every applicant in the country. There are so many patent agents, patent attorneys I see in this participation. I thank each one of you. Even few individual inventors have also joined this IP Manthan. All the intellectual property ambassadors of the country, patent agent, attorneys, please write an article on the Patent Amendments Act. Make the people more aware about such a forward-looking provisions, and make them aware how this is going to benefit to the country. You can share your published article also for our collection of this publicly available information on the Patent Amendments Act. And I do appreciate if you can publish in a regional language, because so many information may be available in English or at max in Hindi. But if you can write a piece of article in a regional language, that will really benefit to the ecosystem. With this appeal, I take a pause on this. We will make an appropriate announcement on an IP office website for a dedicated IP open house on a patent amendments, patent rules amendment. And we will straight away have a questions, queries on this. If you have a question, queries at that point in time, feel free to write in the chat box. Each and every queries will be reviewed if you have posted on the chat box. Thank you very much for joining today's IP Manthan. It means a lot, and I have seen that over 685 participants have joined this. This shows the interest of the IP ecosystem in learning more about the patent amendment rule. Thank you very much. Namaste.
Thank you, sir.
Thank you, sir.